You're saying no corruption?
No.
None?
No. There were some boneheaded decisions out of a
but
local
no mass
office.
corruption?
Not even mass corruption, not even a smidgen of corruption.
Okay.
And in that light, Ms. Eckelbrett, did you hear the president say there was not a smidgen of corruption?
I've heard that he said that, yes, sir.
Ms. Garrison, did you hear the president say there was not a smidgen of corruption? And let me just translate that, because smidgen's not a legal term. I assume he meant scintilla, and I assume he meant criminality instead of corruption. How was he able to make that conclusion? Neither of you have been interviewed by the Bureau, have you?
No, sir.
And according to Mr. Sekulow, of his 41 clients, 3 have been interviewed, or 3 were asked to be interviewed.
Right. Not interviewed yet.
Okay. 0 of 41 have actually been interviewed.
Correct.
All right. So the president says there's not a smidgen of criminality or corruption. Do either of you remember seeing a witness named Lois Lerner sitting at the very table y'all are sitting at? Do you remember her invoking her Fifth Amendment privilege, the same privilege that she targeted some of your groups for trying to educate people about?
I've been advised by my counsel to assert my constitutional right not to testify or answer questions related to the subject matter of this hearing.
Some of your groups just want to simply educate people about the Constitution, the one that she availed herself of the very second she was exposed to criminal investigation. So how can the president say there's not a smidgen of criminality when Lois Lerner invoked the Fifth Amendment? 41 witnesses haven't been interviewed, including the 2 that are here right now. How can he possibly draw that conclusion?
Good question.
I wish one of the colleagues on the other side of the aisle would ask the president how in the world he concluded no criminality when Lois Lerner sat in front of them and invoked her privilege against criminality. How do you square that?
Mr. Gowdy, if I may, she invoked her Fifth Amendment privilege, which she has the right to do, of course, and you and I both respect that, because we now know the reason why. It wasn't perhaps as clear as it was made yesterday. She invoked her Fifth Amendment privilege because she knew, after she made a false statement and a planted question at an ABA meeting, she knew that, in fact, there was her words and her emails, off-plan drafting of rules targeting conservative groups. She also said at a Duke Law Forum that people are asking us what we can do, and she said, I can't do anything until I see the 990s, the tax returns that are filed. That was all going on while she was redrafting the rules with the highest level of the Chief Counsel's office. Mr. Cartwright.
Mr. Sekulow,
yes,
I want to say this. I understand why she invoked her Fifth Amendment privilege. I don't understand why in the hell the President of the United States would prejudge an investigation
I don't either.
before any of your clients were interviewed, before either of these 2 victims, and I know you don't like that word, but I'm using it in the criminal sense of the word, before either of these 2 victims were interviewed. He has gone on national television. He has prejudged the investigation, and in my judgment has compromised the Department of Justice, which leads me to this question, Mr. Sekulow.
Yes, sir.
There is the option, when you have a compromised investigation and a chief executive who has prejudged the outcome before the jury's even gotten all the evidence, he's got an option of appointing a special counsel, right?
Yes, he does.
And the special counsel regulation says if it's extraordinary circumstances that furthers the public interest. Can you think of anything more extraordinary than government targeting people based on their political beliefs?
No, I agree with you 100%. And I also would point to the email of June 14, 2012, which was just released, because this shows the need for a special prosecutor at this point on the criminal aspect of this. And again, Mr. Cartwright, when you asked about the no evidence of politics, let me quote from the email. Don't know who in your organization is keeping tabs on C4s, but since we mentioned potentially addressing them off-plan in 2013, I've got my radar up, and this seemed interesting. These are coming from the most senior people within the chief counsel's office of the IRS, which is a presidential appointee. Again, it's an office I came out of, so I have due respect for the office. But at this point, a special prosecutor to evaluate the criminal sanctions or criminal laws applicable would probably be the best, I believe would be the best way to go, because I don't think the Justice Department right now, again, with due respect to the Justice Department, is institutionally capable of doing this. And I need to say this also, because I thought that the question, Mr. Cartwright, on Ms. Mitchell's legal representation, she has an exceptionally excellent reputation in this town as a lawyer. And her clients tend to be conservative because that's who her clients tend to be. But, you know, I'm a conservative also, but like I said, I've represented the American Civil Liberties Union in cases at the Supreme Court of the United States. I've represented the National Democratic Policy Committee as well. So I don't think it's fair to go after the lawyers in a situation where it is the IRS that is trying to use their procedures to justify their illegal conduct. Remember the apology? They offered the apology.
If the selection criteria were inappropriate and then people were selected for review or delayed in their ability to get a response because of their organization's name, that's intolerable. We're not going to do that. It doesn't happen now. It won't happen going forward. And to the extent that people suffered accordingly, I apologize for that.
You know what? The apology is not accepted.
Mr. Chairman, in conclusion, I believe the ranking subcommittee member said that there are 13 people assigned to this investigation, if I heard correctly. 13 people in 6 months have not had time to interview a single solitary one of Mr. Sekulo's clients. 13 people in 6 months have not had time to interview either of these two witnesses, and yet the chief executive, the President of the United States, has already prejudged the outcome of this investigation. So either it's ongoing or it's not. Either he's wrong or Eric Holder is wrong. In either case, it is time for special counsel, Mr. Chairman.